seen Game of Thrones, they talk about old god, new god, and they swear on their names. So here also we have this old procedure code, new procedure code. So as we are following BNSS now, Bharatiya Nagarik Suraksha Sanhita, I will be talking and referring from it only. The old law has a very wide interpretation because it was in the field for a very long time. But the new law is here, and to a large extent, it's the same. There are significant changes. We would be talking about those changes as well during the course of this talk. So, first of all, let's address the elephant in the room. As the today's lecture is titled "Complaint," drafting complaints. Let's understand. Let's give some thought. What does it actually mean? So, as you all have BNSS, Bharatiya Nagrik Suraksha Sanhita, it has a definition clause in section 2. That definition clause defines defines the complaint. So it's in even in this compilation which I have shared with you. It would be in the beginning, I think, at the page 2. If you may come to the page 2 of the PDF, yeah. So the definition is here. I am reading from the BNSS. So it's 2(1)H. So it says complaint means allegation made orally or in writing to a magistrate with a view to his taking action under this Sanhita that some person, whether known or unknown, has committed an offense but does not include a police report. The definition is quite simple that if you go to a magistrate with a grievance, the grievance could be put forth before the magistrate orally or in writing, and then you are telling the learned magistrate that some person has wronged you in this manner or that manner. That's a complaint. So this is precisely what we mean by complaint. When you go to police with grievances and when you narrate the grievances to police officers, which is the usual course of business, whether in writing or orally, that thing is called information. It's not called complaint. So there is a distinction. So whenever you approach the magistrate with a grievance, you are going with a complaint. Whenever you are going to police with grievances, you are going with information. So here is the vital difference. Another pivotal thing on which everything is going to move again is the definition of a cognizable offense. The cognizable offense has been defined in section 21H, 21G, and it means the section reads cognizable offense means an offense for which the cognizable case means a case in which a police officer may, in accordance with first schedule or under any other law for the time being in force, arrest without warrant. Arrest without warrant. So that's a cognizable offense. It gives ample power to police officers. They don't need judicial orders to begin with. They don't need judicial directions or judicial papers to arrest a person. And that's how a cognizable offense is defined. So, as in the previous lectures, we had already seen that when a cognizable offense has been committed, what offense is cognizable, what offense is not cognizable, we have seen in the definition. And how to brand an offense a cognizable offense or as a non-cognizable offense, that thing has been done in the first schedule of BNSS. That is something which legislature has done. So if you approach the police with a piece of paper or orally, you visit the police station and you tell the police that a cognizable offense has been committed against you. For example, like murder is a cognizable offense. So you could go to police and narrate orally that a cognizable offense has been committed in my presence in my house, and please make note of it and make sure that the justice is done. So if you do that and you disclose through your information a commission of cognizable offense, then as per law under section 173 subsection 1, police is under obligation to register a first information report that's called FIR because your information disclosed commission of a cognizable offense. If they don't do so, you have the option to approach the Superintendent of Police under Section 173, subsection 4, that the necessary action may be taken and the Superintendent of Police will take the necessary action. So that's the law, qua police. But what if the information which you are disclosing relates to the commission of non-cognizable offense? In that case, they will register the case as NCR, non-cognizable report, and they won't take any action further without the authorization of magistrate. And BNSS further defines that in the definition clause, going back to the definition clause again, that if we see the complaint, the explanation proviso, it's written even in this summary note. A report made by a police officer in a case which discloses after investigation the commission of a non-cognizable offense shall be deemed to be a complaint, and the police officer by whom such a report is made shall be deemed to be a complaint. So, complaint is one when you approach the magistrate yourself with a written complaint or an oral grievance, and second would be this one when police officer is filing some report relating to a non-cognizable offense. So these are the definitions of complaint. So as far as cognizable offenses are concerned, the usual remedy which is used like on a broad basis is approaching the police first. But when police doesn't listen you, SHO doesn't listen you, SP doesn't listen you, what do? You go to magistrate in section 175 subsection 3 of BNSS. Earlier it was 156 subsection 3 of CrPC. Then again magistrate has the power to direct the police to register the FIR and do the investigation and take the necessary action. So when you approach a magistrate has multiple options then. He may direct if the of information disclosed by you shows commission of a cognizable offense, then magistrate may simply say that police shall do investigation. But if it does not disclose a cognizable offense, then what to do? Then the magistrate may proceed further and treat it as a complaint case. I will come to the details later. So there is a catch. And now, if the offense, the information which you gave to magistrate discloses commission of a cognizable offense, is the magistrate bound to order FIR? No, he is not. And that is something which we will cover in Ramdev Foods judgment. It's a very interesting proposition that qua cognizable offenses, magistrate honestly has two options. First, if the offense is complex, as stated in Om Prakash Ambadkar judgment, if the information disclosed relates to commission of an offense which is complex in nature, the expertise of police and investigating agency would be required to look into the offense. In those scenarios, ordering registration of FIR is justified. But if the offense is of such a nature, despite being a cognizable offense, that the complainant or applicant himself or herself has or likely to possess all the material, in those situations, in those scenarios, the magistrate would be justified by treating the said complaint or grievance as a complaint case. I will come to the details later. So this is like this is a summary of what is a complaint and what is an FIR. Like if you see the compilation shared by me, you will find that at, there is a small table which we have tried to produce in that compilation. So if you see that table wherein we have tried to make a comparative analysis of both the things, the comparative analysis could be seen at page number 3. I hope we are in page number 3, the later part. It makes a comparative analysis of complaint versus FIR. So the definitions are there. Complaint is before a magistrate. FIR is filed in police station. Complaint could relate to cognizable as well as non-cognizable offense. However, FIR is always related to cognizable offenses. And the purpose is for magistrate to order 156.3 or to proceed, and FIR's purpose is to initiate the police investigation. and the registration part is also there. So in the table we have tried to show how different they are. At times they are overlapping, but sometimes they are different as well. And then as a query might be there that when to file a complaint under BNSS. So first of all, the first idea would be in non-cognizable offenses. What are non-cognizable offenses? Like are defamation. Like if you think you have been defamed by someone, you can file a civil case. Simultaneously, you can also file a criminal case. So in that scenario, if the offense which has been committed against you, in that situation, you can approach the magistrate directly with a complaint. So that would be one scenario. Another thing was like if police refuses to register FIR, even if it's a cognizable offense, then you can approach the magistrate with a complaint and the case can proceed then and there. And the third situation would be requirement of some statute like Negotiable Instrument Act 8081 says that under Section 138, a complaint has to be filed before magistrate in a written manner by the person aggrieved. Then only a cognizance would be taken, otherwise not. This is how it is done. And if you see how a complaint is made, what would be its structure, then the structure part is quite simple. That first of all is like titling, like the court you are approaching, the title of the court, the designation of the learned judge, then the details of the parties. We are living in electronic. All the information you usually receive from your employer, from your institute, or through emails or WhatsApp. So you even give those details. You give the address of the person, name of the person, age of the person, parentage of the person, residence of the person, email, WhatsApp. You give all the details so that if something has to be done, like affecting a service, then no problem comes in the way. So when you mention the parties, you mention all the details related to them and obviously the facts of the case. And the facts of the case need to be specific, like date, time, place, person. And then they shall flow in a chronological manner so that some scene balance is visible. Some sense could be made make out of it. The problem happens when you make vague allegations. Like imagine a woman is living in a matrimonial house and she is suffering abuse from her in-laws. And if she writes in her complaint that I have been suffering abuse for last 5 years, my situation is very bad. I have suffered a lot. Please give me justice. So this complaint discloses that she has been suffering, but where are the details basis on which some offense could be made out? To give a detail, some incident could be cited. Incident like on 15th January 2025, I was in the kitchen. Some incident which might have happened, some incident which actually happened. So if we narrate that incident, and if there is an element of violence in that incident, if given specifically, could lead to the commission of an offense, and the court can proceed on it. So suppose this wife is in kitchen and preparing some food, and some in-law says that what are you preparing? She says I am preparing some vegetable, and that but concerned relative doesn't like that vegetable. They start fighting with her, and the fight slowly turns to the extortion and taunts on bringing less dowry. It extends to the fact that her husband is called in and he gets very agitated in the process and he slaps the wife. So if all these occurrences are put in a systematic manner, giving date, time, place, persons, then it becomes very easy for the court to make out the offense. Definitely, there is an offense which is being committed in this scenario. So, if some some diligence is shown by giving all the necessary facts, then it becomes easy for the court to proceed further in your favor. So that's one thing. And one more important thing would I would discuss here is jurisdiction. Where did the offense happen? So in criminal cases, territorial jurisdiction means a lot. So if The matrimonial house was in South District of Delhi. Then the nearest police station in the South District would have the jurisdiction, and the South District's concerned magistrate of the area would have the jurisdiction. So jurisdiction has to be seen very sincerely by anyone who is drafting the petition. And jurisdiction could only be ascertained by seeing the facts and seeing them diligently. It might happen that 4 or 5 places would be having jurisdictions. This couple might have lived in different places. They might have lived in South District of Delhi. They might have lived in Jaipur. They might have lived in Bangalore in different points of time. And in those different points of time, all those courts and police stations would be having jurisdiction. But it's your job to find out what is the most convenient forum and where most of the cause of action, the most substantive cause of the action arose. So that's something which has to be done by seeing the facts, by seeing the situation. And the reliefs which you are asking, they have to be drafted diligently in, and the whole thing has to be in such a manner that some seam balance comes out, some story comes out which supports your relief. And the documents, like if you were beaten up very badly by your in-laws, you must have gone to some hospital. That's unfortunate, but that's the usual course of business. If someone gets beaten up badly, they visit a hospital, they meet a doctor, they tell their misery to the doctor, and doctor writes those things in the prescription. So at times there is MLC, medical legal uh, case is there. Doctor writes it in detail. So those documents are always there. People at times get very uh, fearsome. They become very anxious, and out of anxiety, they call police to seek some protection. And every police call, when you call 100, has a record. GD entry, general diary entry is done in police register that this person called with this problem and we did this action. So a lot of documents are getting created in the process. So it's it's necessary when you are filing a complaint case that an endeavor shall be made to collect all these documents. You collect your medical records. You you collect your uh, you collect your, if possible, you collect your this police phone record, all the call logs you might be having. You might have taken some pictures. You might have taken some videos. Some there could be different things. So it's very situation dependent what's happening and what's not happening. So giving a very serious consideration to documents surrounding the circumstances is very important. Once you have collected the documents, look at the people, witnesses, people who could become the witness. So it may just happen that when violence happened to this woman in the house, there might be different relatives there. There might be people, there might be neighbors. So you could talk to these people, and if they agree, they can be cited as witnesses. So doing this whole exercise is very important because it makes your case very strong. Why we are supposed to do all this? Because when we are filing criminal when we are filing complaint before magistrate, if the magistrate takes cognizance, if magistrate, I will come to the details of the whole process, how the cognizance happens, because it's a very, it sounds very easy, but it's a very detailed legal process. So when a magistrate take cognizance of the offense alleged in this complaint, then the whole criminal procedure starts and the criminal trial commences. And that trial is no different than a trial which might have been commenced on a police report. So imagine two scenarios. There is a theft which has been committed in your house. You go to police, you give the information, they register FIR because it's a cognizable offense. Now the police will investigate everything. They will find out the documents. They will find out the CCTVs. They will find out the fingerprints. They will find out the person concerned. They will collect everything in a report called police report, submit it to the magistrate. Magistrate will take cognizance, and the criminal trial against the accused persons will start. That's one way. Another way is that police doesn't listen you. You don't find any reports. You file a complaint case before the magistrate, and the magistrate, after examining you, after seeing your documents, after doing the necessary inquiry, thinks that a case is made out and issues the process and takes the cognizance. Then again, the criminal trial commences. And what is the basis of this criminal trial? The basis is the documents given by you. The basis is the witness cited by you. So that's the whole point. That's why this complaint has to be made with all the diligence, because here you don't have the police assistance.